Moving along with global sourcing and contract negotiations, we're going to pick up with the topic of transfer of risk, and right below that, transfer of title. Two very important clauses that must be included in a contract between a supplier and a U.S. importer. We'll first note that there is an asterisk next to transfer of risk. That means that it is indeed covered by Incoterms. But when we talk about the transfer of risk, it's referring specifically to the risk of loss or damage to the goods in transit. We will emphatically state that is not the same thing as transfer of title. That is transfer of ownership of the goods. There's a difference between risk and ownership. Incoterms do not cover transfer of title. That's why it's listed here as a separate clause in a contract. Risk and title transfer are not the same thing. We should also include in our contract a clause around the main mode of transport: air freight, ocean freight, truck or rail between Canada, the U.S., and or Mexico. Another asterisk is the responsibility for transportation charges. Who pays for different modes of transport? Domestic transportation to a port of export in the country of origin, that main mode of transport. Domestic delivery in the United States. Incoterms cover that. And Incoterms cover designation of the freight forwarder. Whatever Incoterm is chosen between a supplier and a U.S. importer, one of the two parties is going to be responsible for designating the freight forwarder. Incoterms help to make that designation. We'll note we're seeing a lot of items here that do have an asterisk next to it. That's because we're getting into the transportation component. We'll continue on with that theme on this slide. Provision of the transport document, that refers to who's responsible for procuring a bill of lading, an airway bill, an ocean bill of lading, a truck bill of lading. That's covered by Incoterms. Provision of commercial documents, also covered by Incoterms. But clearly, the responsibility of providing commercial docs, and again, we're talking about the commercial invoice, packing list, maybe a certificate of origin, etc. That's the responsibility of the vendor, the international supplier. Cargo insurance, also covered by Incoterms. However, it's important to say that cargo insurance is a commercial decision. Nobody has to get insurance, and we're talking about insurance on the movement of the goods, related to the risk of loss or damage to those goods. As a brief aside, there are only two Incoterms that require the seller, the vendor, to get insurance on behalf of the buyer, in our case, the U.S. importer. That's CIF and CIP. Transitioning away a little bit from some of those asterisk-laden clauses, a penalty clause for late shipments. This is an important one because the timing of shipments to the U.S. importer are quite important, and if a supplier is constantly late, there has to be a penalty for that. Last one on this slide, a good idea to include a clause on the rules around converting ocean freight to air freight. We all know that air freight is much more expensive than ocean freight. Oftentimes, that conversion is made because shipments are late. Maybe the vendor is late. Maybe the U.S. importer placed a purchase order late. Whatever the circumstances, there should be at least clear policies, if not a clause in the contract, around how ocean freight can be converted to air freight and who's responsible for paying for it. The next three have asterisks again. Customs clearance at destination, payment of duties and taxes, both covered by Incoterms, usually. With the exception of the Incoterm delivered duty paid, it is the buyer, the U.S. importer, that is responsible for customs clearance at destination, the destination being the U.S., as well as the payment of duties and taxes. We'll see lots of examples of how that works moving forward. We see again a reminder on risk of loss or damage to the goods, definitely covered by Incoterms. We spoke of that a moment ago, but we should also include in our contract, independent of Incoterms, things like product warranties and the policy around product returns. In an international environment, that can be an expensive proposition, returning goods to a supplier in a different country. Hopefully, that's a last resort option for the U.S. importer, but there has to be clear agreement in the contract on how that's going to work. Under what conditions can product be returned? And most importantly, who's going to pay for those returns? Because again, that's very, very expensive. Definitely moving away from transportation and risk-related topics in an agreement, we're talking about things like loss mitigation. And this means if something goes wrong, if goods are indeed lost or damaged, or there is a loss of market because of a late shipment, what is the responsibility of the vendor to take every measure possible to mitigate that loss, whether it's replacement of goods or converting ocean freight to air freight? Loss mitigation is typically about the parties taking every measure possible to avert a total disaster, basically, on a shipment. One important clause that sometimes the parties don't consider are amendments to the contract after a contract is agreed upon and signed. What if the parties or one of the parties wants to make a change? That's what an amendment is, a change to the contract. Maybe add something, omit something, or change the terms of a particular clause. We want to be explicit about how that's going to work. Assignment of the contract is another essential point, and that means the ability of the parties to transfer their rights to the contract to another party. So the U.S. importer might have the ability to assign their rights to the contract to another party. Or the supplier in, say, Norway has money owed to them by a U.S. importer as part of a contract and assigns the collection rights to another party. That's just one example, but that's what assignment means. If things go wrong with a contract, how are the terms of the contract enforced, and what are the remedies to make whatever went wrong right? Liquidated damages, these are subjects where things really go wrong in a relationship with a vendor and a U.S. importer. So what are the amounts of monies that the parties can collect if things really go so bad that legal action has to be taken? It's called liquidated damages, monetary damages, actual monies that are paid between the parties to make up for whatever went wrong. We're starting to see some real legalese here, but they're important to mention. And it's also important to mention that we at Mercado are not lawyers. We're simply sharing information. But the first on this slide is a clause on what's referred to as severability of provisions. And that just means that if we have 20 clauses in a contract, and for whatever reason, one of those clauses is found to be unenforceable, maybe it was illegal to have that clause in the contract in the first place, severability means that the remaining 19 clauses are still enforced. Always important to have a clause on severability in an international agreement. Mention of force majeure, acts of God, things that happen in a relationship that are out of the control of the parties and cause shipments to be late or losses, etc. A late shipment due to a monsoon and a ship couldn't sail. The tsunami in Japan going back some years ago that disrupted maritime supply chains dramatically. Things that happen that are out of the control of the parties that have to be acknowledged. Force majeure, it's called. How can a contract be canceled, if at all? And two important points to wrap up this slide. What law is going to be applied to a contract? The governing law. Going back to our brief example of a moment ago, a vendor in Norway selling to an importer in the United States. There's a contract in place governing the relationship. Will the law of Norway apply? Will the law of the United States apply should things go off the rails? That has to be agreed upon ahead of time. And then, perhaps not required, but a clause on arbitration provisions, meaning that the parties agree ahead of time in writing, should something go wrong and there's a legal dispute, it won't be in a court, it will be through a third-party neutral arbitrator who listens to the facts of the case and makes a binding decision on behalf of the parties. Court and arbitration are two different things. The buyer and the seller have to decide how they're going to proceed in that regard. Let's wrap up this section with a supply chain perspective on the strategic use of Incoterms rules. They really are that important that we want to hit them one more time before proceeding. One of the least understood and oftentimes misinterpreted aspect of global trade is Incoterms rules. First established by the International Chamber of Commerce in Paris, France in 1936, the strategic use of Incoterms is essential to any comprehensive sourcing strategy, both from a contractual perspective, but also out in the field and how goods move tactically after sourcing decisions are made, purchasing gets involved, and goods are moving. Incoterms are about the movement of goods and who's responsible for what. Incoterms, also known as shipping terms, are most associated with the division of transportation and customs-related expenses between a seller and a buyer. Who pays for what from a transportation perspective? We talked about this a moment ago. Who pays for inland freight at origin? Who pays for air freight as the main mode of transport? Who pays for delivery from the port of Houston to a factory up in Dallas? The answer to that question is it depends on the Incoterms rule agreed upon between the seller and the buyer. But transportation and the division thereof is a big part of what Incoterms do. What U.S. importers sometimes don't realize is that Incoterms also identify the physical place in the supply chain where risk of loss or damage to the goods shifts from seller to buyer. We talked about this in some detail. Perhaps a bit counterintuitive, Incoterms do not deal with the transfer of title to goods. This point must be treated separately in a contract. That is a fact, not subject to debate. It is explicitly stated in the Incoterms publication that can be purchased through the ICC on its website, the International Chamber of Commerce. Of equal importance, Incoterms cover a number of operational points that are oftentimes listed as separate clauses in a contract. We talked about this too. We showed them as asterisks next to those points. However, when an Incoterms rule is clearly stated in an agreement, questions around things like who is responsible for designating the freight forwarder, who pays for goods inspection at origin, what type of packaging must be used, and who is required to obtain an ocean bill of lading are automatically determined by the chosen Incoterm. Pretty important stuff. Otherwise, an agreement can become cluttered by having to list all these different things. We can state the Incoterms rule in the agreement, and they are automatically covered. The point is, we have to understand, as the U.S. importer, what we're agreeing to from both a transportation, risk of loss or damage, and who does what perspective. Very important stuff. We're going to wrap up this section here, and when we come back, begin to talk about ethical sourcing. See you then.